2026 Employment Law, what you need to know. Welcome back to the channel, HR Curve 360. 2026 is set to be one of the biggest shakeups in UK employment law in decades. With the Employment Rights Act now receiving royal assent, employers must move from speculation to preparation. While some reforms won't arrive until 2027, most major changes land in 2026, starting in April and October. Let's break down the key changes and what businesses should prepare for. Changes coming in April 2026, Day 1 parental rights. Employees will get Day 1 rights to paternity and parental leave. No more waiting 26 weeks or 1 year. Parental leave remains unpaid, but eligibility expands. Employers must update policies and prepare for increased admin and discrimination risks. Collective redundancy penalties double. Maximum protective award increases from 90 to 180 days pay. Applies if employers fail to properly consult on large-scale redundancies. Higher financial and litigation risk for restructuring. Statutory CIPD reform. Lower earnings limit removed. More workers eligible. SSP paid from day 1 of sickness. Pay set at 118 times 65 or 80% of weekly pay. Whichever is lower, employers must tighten absence monitoring processes. Fair Work Agency launch. New Fair Work Agency will enforce worker rights. Combines HMRC minimum wage enforcement and labour inspectors. Can take employers to tribunal on a worker's behalf. Accurate wage records and compliance will be critical. Whistleblowing and NDA changes. Sexual harassment becomes protected. Whistleblowing. Workers protected from dismissal and detriment when reporting. NDAs restricting the disclosure of harassment or discrimination will be prohibited. Settlement agreements and policies must be reviewed. Pay and minimum wage increases. National living wage, 21 plus, rises to $12.71 per hour. 18, 20-year-olds, $10.85 per hour. Apprentices and under 18s, $8 per hour. Statutory family-related pay rates also increase. Expanded trade union rights. Easier industrial action ballots. Electronic balloting introduced. Shorter notice for industrial action. Mandates last up to 12 months. Changes coming in October 2026. Ban on fire and rehire. Automatically unfair to dismiss workers for refusing key contract changes. Applies to pay, hours, holidays, and shift patterns. Only defense. Serious financial distress with no alternative. Employers should review contracts and make changes early where needed. Stronger duty to prevent sexual harassment. Employers must take all reasonable steps, not just reasonable steps. Includes protection from third-party harassment. Proactive prevention is essential. More trade union obligations. Employers must tell workers in writing about their right to join a trade union. Paid time off and access to facilities for union work. Unions can request access to workplaces. Tipping law tightened. Employers must consult staff on tipping policies. Policies must be reviewed every 3 years. Staff must receive anonymized consultation feedback. Tribunal time limits extended. Employees will have 6 months, up from 3, to bring tribunal claims. 2026 marks a major reset of employment rights in the UK. Responsibility of employers. Review contracts and policies now. Train managers and HR teams. Improve record keeping and consultation processes. Seek early legal advice where needed. In 2026, proactive action is the key to avoiding compliance failures and expensive claims. Stay tuned and subscribe HR Curve 360 for more UK employment law updates and HR insights.